Good morning, Your Honours. Case number IT 95-9T, the prosecutor versus BLAGOJA Simić, MIROSLAVA TADIĆ, and Simo Saric.
May I have the parties, please, the prosecution?
Good morning, Your Honours. If Your Honours please, my name is DeFazio. I appear on behalf of the prosecution together with my colleagues Mr. Ray, Mr. Weiner, Mr. Barag, and Ms. Reedy.
Thank you. The defense, please.
Good morning, Your Honors. On behalf of Dr. Blagoje Simić, attorneys Pantelić and Vuković, thank you.
Yes.
Good morning, Your Honor. On behalf of defense for Mr. Miroslav Tadić, Novak Lukić, and Dragan Krgović.
Thank you. Yes.
Dobro jutro, časni.
Good morning, Your Honors. I'm Borislav Pisarević, defense counsel for Mr. ZARIĆ, and with me is my colleague, Mr. Alexander Lazarević.
May I find out from the accused persons where they can follow the proceedings? Dr. Blagoje Simić, can you hear the proceedings?
Yes, Your Honor.
Thank you. Mr. Miroslav Tadić, please.
Yes, Your Honor.
Simo Saric, please.
Yes, Your Honor.
Trial Chamber 2 is sitting this morning to deliver judgment in the trial of the three accused persons, Dr. Blagoje Simić, Miroslav Tadić, and Simo Saric, who are jointly charged under the 5th amended indictment of 30th May 2002 with individual criminal responsibility pursuant to Article 7.1 of the Statute of the Tribunal for 2 counts of crimes against humanity under Article 5 of the Statute, namely persecutions and deportation, and 1 count of a grave breach of the Geneva Conventions of 1949 under Article 2 of the Statute, namely unlawful deportation and transfer. For purposes of this hearing, the trial chamber delivers a summary of its findings and the disposition. This is a summary only and forms no part of the judgment. The only authoritative account of the trial chamber's findings and its reasons for those findings is found in the written judgment, copies of which will be made available to the parties and to the public at the conclusion of this hearing. The summary of the findings delivered today represent the ruling of the majority. A separate and partly dissenting opinion of Judge Lindom is appended to the judgment. The accused were originally indicted together with Slobodan Miljkovi, aka Lugar, Milan Simić, and Stevan Todorovi in the first indictment brought against them on 21st July 1995. Following guilty pleas by Stevan Todorovi and Milan Simić, the proceedings against these two were separated from the other accused, and upon the passing away of Slobodan Miljkovi, the proceedings against him were terminated. The trial of the accused covered events which occurred in the municipalities of Bosanski, Simić, and Ojak, located as shown on the map appended to the judgment, and elsewhere in the territory of Bosnia and Herzegovina. The town of Bosanski Simić was of strategic importance for the conduct of military operations. The municipality formed part of the so-called Posavina Corridor, a narrow strip of flat land along the Sava River, connecting the Serb-controlled areas within Croatia and the Bosnian Serb territories and the Republic of Serbia. The corridor was the easiest and shortest way to establish a ground route between the Serb-controlled areas within Croatia to the west, Republika Srpska Krajina, and Serbia to the east. Factor findings. The accused held central positions within these areas covered in the indictment. Dr. Blagoje Simić, a medical doctor, was president of the municipal board of the Serbian Democratic Party and the president of the Serb crisis staff in the municipality of Bosanski Simić. He continued as president when the crisis staff was renamed the War Presidency. He was the highest-ranking civilian official in the municipality. Miroslav Tadić, a retired school teacher, was assistant commander for logistics within the 4th Detachment, commander of the Civil Protection Staff, an ex-official member of the crisis staff, and a responsible member of the Exchange Commission in the municipality of Bosanski Simić. Simo ZARIĆA was assistant commander for intelligence, reconnaissance, morale, and information in the 4th Detachment, chief of national security in Bosanski Simić from 29th April 1992 to 19th May 1992, and deputy to the president of the Civilian Council in Ojak. The Trial Chamber finds that the events which took place in the municipalities of Bosanski Simić and Ojak between 17th April 1992 and 31st December 1993 constituted a widespread and systematic attack on the civilian population. This attack included the forcible takeover of power in Bosanski Simić by members of the paramilitaries and Serb police, and the subsequent acts of persecution and deportation against non-Serb civilians. The Trial Chamber is also satisfied that some members of the 17th Tactical Group of the JNA were present in the town of Bosanski Simić on 17th April 1992. A state of armed conflict existed in the Republic of Bosnia and Herzegovina during the above-mentioned period, and there was a nexus between the armed conflict and the acts of the accused persons. The Trial Chamber does not consider whether or not the armed conflict was international in character. In the Trial Chamber's view, the prosecution's pleading in the indictment of a state of armed conflict did not inform the defense of the material facts of the jurisdictional requirements of the charge of unlawful deportation or transfer based on Article 2 of the statute. The Trial Chamber holds that in determination of the charges against the accused, it cannot make a legal assessment of the facts that do not conform to the indictment, and consequently dismisses count 3 of the indictment. The Trial Chamber finds that the amended indictment and the prosecution's submissions were not detailed and specific enough to have put the defense on notice that the prosecution intended to rely on a joint criminal enterprise theory beyond a basic form of joint criminal enterprise. The Trial Chamber has, therefore, considered only the basic form of joint criminal enterprise pursuant to Article 7.1 of the statute, in addition to the other forms of criminal responsibility listed in this article. The Trial Chamber proceeds to state its findings on individual criminal responsibility for the underlying acts of persecution as charged in count 1 of the indictment of each accused. The Trial Chamber begins with its findings on the accused's participation through a joint criminal enterprise to commit persecutions. Individual criminal responsibility, joint criminal enterprise, Article 7.1. The Trial Chamber is satisfied upon the evidence that members of the crisis staff, including BLAGOJA Simić as president, the Serb police, including the chief of police, Stevan Todorovi, who was also a member of the crisis staff, Serb paramilitaries, including Debeli, Serko Radovanović, Pukvonović, Sani, Dragan Dojević, Lugar, Slobodan Miljkovi, and Laki Predrag Lazarević, and the 17th Technical Group of the JNA were participants in a basic form of joint criminal enterprise, sharing the same intent to execute the common plan to persecute non-Serb civilians in the Bosanski Simić municipality. The Trial Chamber infers the common plan of the joint criminal enterprise from all the circumstances. There is sufficient evidence to conclude that participants in the joint criminal enterprise acted in unison to execute a plan that included the forcible takeover of the town of Bosanski Simić, taking over vital facilities and institutions in the town, and persecuting non-Serb civilians in the municipality of Bosanski Simić within the period set forth in the amended indictment. This common plan was aimed at committing persecutions against non-Serbs, including acts of unlawful arrest and detention, cruel and inhumane treatment, including beatings, torture, forced labor assignments, and confinement under inhumane conditions, deportations, and forcible transfer. Dr. BLAGOJA Simić, as President of the Municipal Assembly and the Crisis Staff, later named the War Presidency, was at the apex of the joint criminal enterprise at the municipal level. He was the highest-ranking civilian in Bosanski Samić municipality. He knew that his role and authority were essential for the accomplishment of the common goal of persecutions. The trial chamber is convinced that BLAGOJA Simić and the participants acted with the shared intent to pursue their common goal of persecutions. The trial chamber holds that while BLAGOJA Simić was a participant in the joint criminal enterprise, there was no evidence to conclude that Miroslav TADIĆ and Simo ZARIĆ were participants. The trial chamber turns now to deliver its specific findings on Dr. BLAGOJA Simić's participation in the joint criminal enterprise to commit these underlying acts of persecutions, and in addition to give its findings on the responsibility of Miroslav TADIĆ and Simo ZARIĆ pursuant to Article 7.1 of the statute for the crime of persecutions charged in count 1 of the indictment. Crimes against humanity, persecutions, count 1. A. Forcible takeover. With respect to the act of forcible takeover as charged as an underlying act of persecutions in count 1, the trial chamber concludes that it does not reach the level of gravity as the other crimes against humanity, and on its own does not amount to persecutions. The trial chamber notes, however, that a forcible takeover may serve as the basis for perpetration of other persecutory acts, as it provides the conditions necessary for adoption and enforcement of policies infringing upon basic rights of citizens on the basis of their political, ethnic, or religious background. B. Unlawful arrest and detention. The trial chamber is satisfied that following the takeover in Bosanski Samić municipality on 17 April 1992 and continuing throughout 1992, large-scale arrests of Bosnian Muslim and Bosnian Croat civilians were carried out in the municipality by members of the local Serb police and paramilitaries from Serbia. Some members of the 4th Detachment also conducted arrests. Non-Serbs were arrested on racial and political grounds, not because there was a reasonable suspicion that they had committed any offenses pursuant to national or international law. Non-Serb civilians were detained in facilities in Bosanski Samić, the police station, territorial defense building, primary and secondary schools, Zastavica, Herzegovina, and elsewhere in Bosnia and Herzegovina, including Bečko and Bijeljina. The arrest and continued detention were arbitrary and without lawful basis. Detainees were not given reasons for their arrests and continued detention, and in the very few instances where trials were conducted in Bijeljina and Batković, these did not respect rights to a fair trial, the liberty and security of the person, as enshrined in Articles 5 and 6 of the European Convention on Human Rights and Articles 9 and 14 of the International Covenant on Civil and Political Rights. The trial chamber finds that the only reasonable inference that can be drawn from these facts is that BLAGOJA Simić shared the intent of the other participants in the joint criminal enterprise in executing the common plan of persecutions and participated in this joint criminal enterprise through the unlawful arrests and detention of non-Serb civilians. The police, paramilitaries, crisis staff, and 17th Tactical Group of the JNA worked together to maintain the system of arrests and detentions. As president of the crisis staff, BLAGOJA Simić presided over meetings where the operations of municipal authorities were discussed. The chief of police, Stevan Todorovi, reported to the crisis staff on the situation of arrests and detentions in Bosanski Samić. BLAGOJA Simić was in a position of strong influence and control and did not take any significant steps in this position to prevent the continued arrests and detentions. The trial chamber is not satisfied that there is sufficient evidence that Miroslav Tadić participated in the unlawful arrest and detention of non-Serbs. While Miroslav Tadić had knowledge of the discriminatory intent of the joint criminal enterprise, through his position as a member of the Exchange Commission, the actions or omissions of Miroslav Tadić cannot be considered to have had a substantial effect on the perpetration of unlawful arrests and detentions, and as such did not aid and abet the joint criminal enterprise. The trial chamber is not satisfied that Simo ZARIĆA participated in the unlawful arrests and detention of non-Serbs. In his position as Assistant Commander for Intelligence, Reconnaissance, Morale and Information in the Fourth Judgement, he conducted interrogations of detainees at the SUP and in Bečko. The trial chamber is not satisfied that these acts had a substantial effect on the perpetration of the unlawful arrests and detentions. Simo ZARIĆA did not order any arrests and in several instances advocated the release of detainees. C. Interrogations. With respect to the charge against Simo ZARIĆA of interrogation of Bosnian Croats and Bosnian Muslims and other non-Serb civilians who had been arrested and detained and forcing them to sign false and coerced statements, the trial chamber finds that while there is evidence that Simo ZARIČ conducted interrogations of detainees in the police station in Bosanski Simić and in Bečko, there is no evidence that he forced them to sign false and coerced statements. Furthermore, the trial chamber holds that interrogations as charged alone do not meet the serious requirement to constitute persecution and a crime against humanity. The trial chamber has accordingly considered acts of interrogation together with the charge of persecution for acts of cruel and inhumane treatment. Judge Williams will now deliver the next part of the judgment.
D. Cruel and inhumane treatment. The trial chamber considers that as the pleading of cruel and inhumane treatment, including beatings, torture, forced labor assignments, and confinement under inhumane conditions, emphasis added, is too vague and unspecific to have provided notice to the defense of the incidents not explicitly set out in the amended indictment. This materially impaired the ability of the accused to effectively prepare their defense. Therefore, the trial chamber does not consider any cruel and inhumane treatment falling outside the categories of beatings, forced labor assignments, and confinement under inhumane conditions. The trial chamber is, however, satisfied that torture was not pleaded as an underlying act of cruel and inhumane treatment, but rather that cruel and inhumane treatment and torture were pleaded on the same level as underlying acts of persecution. The trial chamber finds that detainees were subject to repetitive beatings by paramilitaries and Serb police, causing severe pain and suffering both mentally and physically that constituted cruel and inhumane treatment. These acts were committed on discriminatory grounds constituting persecution. Other acts that included sexual assaults, the extraction of teeth, and threat of execution constituted torture. These acts caused severe physical and mental pain and suffering and occurred in order to discriminate on ethnic grounds against the victims. Non-Serb civilians who were detained in facilities in Bosanski Simić and Herzegovina and Bijeljina were confined under inhumane conditions which constituted cruel and inhumane treatment. They did not have sufficient space, food or water, and were subject to humiliation and degradation. They suffered from unhygienic conditions and did not have appropriate access to medical care. the trial chamber finds that they were confined under inhumane conditions on discriminatory grounds. The trial chamber is not, however, satisfied beyond reasonable doubt that the living conditions of the non-Serbs who were held in ZARIĆA amounted to confinement under inhumane conditions. The trial chamber is satisfied that BLAGOJA Simić participated in the joint criminal enterprise to persecute non-Serb prisoners in the detention facilities in the town of Bosanski Samić through cruel and inhumane treatment, including beatings, torture, and confinement under inhumane conditions. The trial chamber, however, is not satisfied that he participated in the joint criminal enterprise to persecute non-Serb detainees through cruel and inhumane treatment in the detention facilities in Cerkvina, Brčko, and Bijeljina. The trial chamber is not satisfied that the prosecution has adduced sufficient evidence to prove that Miroslav Tadić's conduct had a substantial effect on the perpetration of the crime. The trial chamber is not satisfied that Miroslav Tadić had the authority to restrain any perpetrator from committing persecutory acts, including beatings, torture, and confinement under inhumane conditions against the non-Serb prisoners in the detention centers in Bosanski Samić, Cerkvina, Brčko, or Bijeljina. The trial chamber is satisfied that Simo Zarić aided and abetted the joint criminal enterprise to persecute non-Serb prisoners in the detention facilities in Bosanski Samić through cruel and inhumane treatment, including beatings, torture, and confinement under inhumane conditions. Simo Zarić conducted interrogations with non-Serb prisoners who had been beaten. The trial chamber accepts that he did not take part in the beatings and that he did not approve of them. However, the trial chamber finds that his participation in the interrogations and in the interview of non-Serb prisoners by TV Novi Sad gave encouragement and moral support to the perpetrators of the cruel and inhumane treatment of non-Serb prisoners. In this context, the trial chamber takes into consideration that Simo Zarić was a former chief of the SUP in Bosanski Samić, assistant commander for intelligence in the 4th Detachment, and a person highly engaged and respected in the social and cultural life in Bosanski Samić. The trial chamber, however, does not place any weight on his brief appointment as Chief of National Security. The trial chamber finds that these characteristics of Simo Zarić prove beyond reasonable doubt that his participation in interrogations had a substantial effect on the perpetration of the mistreatment. While the trial chamber is not satisfied that Simo Zarić shared the discriminatory intent of the perpetrators, the trial chamber finds that Simo Zarić was aware of such intent. For these reasons, the trial chamber is satisfied beyond reasonable doubt that Simo Zarić incurred criminal responsibility as an aider and abettor of persecutions. His criminal responsibility covers cruel and inhumane treatment committed until July 1992, when he was appointed Assistant President of the Civilian Military Council in Ojak Municipality. The trial chamber is not, however, satisfied that Simo Zarić shared or was aware of the discriminatory intent of the perpetrators of persecution through cruel and inhumane treatment, including beatings, torture, and confinement under inhumane conditions in Brčko and Bijeljina. The evidence adduced by the prosecution does not prove beyond reasonable doubt that Simo Zarić had such awareness. Simo Zarić himself only acknowledged that he knew of persecutions against non-Serb civilians in the detention facilities in Bosanski Samić. The trial chamber is not satisfied beyond reasonable doubt that Simo Zarić made a substantial contribution to the persecution of non-Serb prisoners through cruel and inhumane treatment, including beatings, torture, and confinement under inhumane conditions in Herzegovina.